Item number 1.
Wait, please, my lords. This is a PIL, my lords, for the constitution of my lords, Linguistic Minority Development Board in the state of Meghalaya. The Meghalaya, my lords, is home to various minorities who are also minorities under, well, it's Article 31. They have set up various educational institutions and otherwise. Now, there was a report by the commissioner for linguistic minorities was appointed, my lords, by the central government. And under that, my lords, there were certain recommendations given to Meghalaya that there should be a board. Now, the petitioner before your lordships, my lords, is an association for the development of that aspect. And my lords, various representations from time to time have been given to the state. Unfortunately, my lords, there has been no response prompting them to then, my lords, come before your lordships. If I may take your lordships to the, my lords, recommendations of the board, that my lords would find at page 145. It starts from page 134, my lords, Annexure 7.
Page 145.
My lords, that is deals with Meghalaya, my lords. Because that was, my lords, for the entire country. And the recommendations, my lords, if I may change, take your lordships directly to the recommendations which has prompted us to come here, my lords, at page 146 at G and H. Well, it's at G. The recommendation is the state government needs to institute wide publicity of the safeguards and facilities available to the linguistic minorities so as to spread awareness among them in the state. And H, my lords, the state government is advised to set up a state-level committee under the chairmanship of the Chief Secretary to monitor the implementation of the safeguards for the linguistic minorities in the state. Similarly, the district-level committee under the chairmanship of the district collector may also be instituted to ensure effective implementation of the safeguards of linguistic minorities. Now, this was given, my lords, way back in 29/3/2016.
So page 145 contains the purposes of this.
My lords, it does. As a matter of fact, my lords would have seen the status of implementation of the safeguards of linguistic minorities. There's a very negative note by the commissioner at 18.3. It says, my lords, it's a matter of concern that no reply has been received from the state government to the questionnaire for this report of the Commissioner for Linguistic Minorities in India. The status of implementation of the constitutional and other safeguards for linguistic minorities could not be ascertained in the absence of complete and comprehensive response from the government of Meghalaya. Therefore, the recommendations of the 51st report are reiterated. Even so, my lords, after this, till today, it's almost 10 years have elapsed, my lords, and in spite of repeated representations from various ends, including various representations made by the petitioner, there is no response forthcoming from the state.
What percentage would constitute minority?
My lords, the table is given on top at page 145, if my lords kindly have a look.
Khasi is 47.05.
My lords, their majority, Garos, my lords, 31.41. Then Bengalis, my lords, is 8.01. Nepali, Gorkhali 2.25, 2.16, 1.
No, linguistically,
Linguistically, my lords.
below what percentage would be considered as a minority? Is there any yardstick?
There is no specific yardstick, my lords. That would depend on the demography of each state.
So here it should be Bengali downwards.
Bengali downwards, my lords. Which are the states and locals? Mizoram? Well, I'm instructed in the northeast, states like Assam and Tripura have already come up with these boards, Millets. It is Meghalaya being Millets having a multicultural presence. It was but natural, Millets, that this kind of a board should actually be operating because there are numerous minority institutions, Millets, which are there, and they need to be Millets.
Yes, Mr. Khan.
Please, Your Lordship. Lordship, I'll just take Your Lordship to first. Lordship, page 135.
Yes.
Lordship has got it. Lordship, this is the forwarding letter for that 52nd report. Lordship will find on the top, the date is 29 March 2016. Lordship.
Yes.
Lordship, this has been addressed by the Commissioner of Linguistic Minorities in India to the Honorable President of India. So there was a forwarding letter of the report. The relevant part, Lordship, is that paragraph 3, second and third. The report records its finding and recommendation for appropriate action by the state governments and union territories as applicable. So, the next paragraph, Your Lordship. The report may kindly be laid on table of both the House of Parliament in terms of Article 350B, subclause 2 of the Constitution of India. So, Your Lordship, I am representing respondent number 125, Commissioner of Linguistic Minority, their party, Your Lordship, they are 6 and 7, Union of India. Now, this fact, Your Lordship, when the report, 52nd report was forwarded to the Honorable President of India, and there is a requirement of law. Lordship, I will just take Your Lordship to Article 350B of the Constitution of India. Lordship, Constitution of India, Lordship.
There shall be a special officer.
There shall be a special officer for linguistic minorities to be appointed by President. It shall be duty of the special officer to investigate all matters relating to safeguards provided for linguistic minorities under this Constitution, and the report to the President upon those matters and such intervals as the President may direct, and the President shall cause all such report to be laid before each House of Parliament and sent to government of the states concerned. Lordship, my first submission here is this: the forwarding letter by the Commissioner of Linguistic Minorities on 29/3/2016, when it had forwarded the letter to the Honorable President of India, it was complying with the requirement of Article 350B, subclause 2. My first condition, Your Lordship, here is this: there is no pleading in the entire PIL that the report has been effected by both Houses of Parliament, and after both being effected by both Houses of Parliament, the report has received the majority vote from both Houses of Parliament, and then has gone back to the President, and the President has issued a notification. With my limited submission, Your Lordship, that is a regular process in which how the report is effected. See, there is absolutely no pleading in the entire PIL. So at this stage, Your Lordship, with my limited submission, since 5 and 6 are Unity of India party, so any rights that would accrue based on the 52nd report could not have a legal sanctity, Your Lordship, without compliance of Article 350B2.
A date before Houses of Parliament to means a suitable enactment would be made.
No, not enactment. Lordship, perhaps Union of India will be the appropriate respondent to answer. With my limited understanding, Lordship, once it's approved, then a formal notification will be issued by the President of India that this report has received the. No, it was only in the stage of forwarding. The purpose of reading page 135 was, Lordship, was only that the Commissioner of Linguistic Minority had forwarded this 52nd report for further consideration. My respectful submission, Lordship, in the entire PIL, whether the further consideration as per Article 350B2 was considered and has received the approval of Parliament, and the President is.
But how do you get that? It might be just for records.
Yes.
It doesn't say for approval of the Parliament.
No, not for approval, Your Lordship. The language says report shall be laid before each House of Parliament and sent to the government of the states concerned. Only limited submission, Your Lordship. This forwarding letter says given to the President for laying before the House of Parliament.
But what about the recommendations in that document?
Lordship, I'm not going to the merit of the document, because first we have to overcome the hurdle, Lordship, whether it was laid before the House of Parliament or not, because there is no pleading in the entire PL. Lordship, once there is a pleading, it was laid, and the Union of India is the appropriate respondent, Lordship, to answer that query. Then we can come to the next issue.
Who's appearing for Union of India?
Union of India, unfortunately,
Because
Lordship.
we've served notice on the Office of the Learned DSGI. I think Mr. R. Debnath is shown as the counsel appearing.
And 5, 6 and 7.
So Article
You are representing 1 to 5.
1 to 5.
5.
Because, Your Lordship, my learned friend has read out page 145 as
Let
that.
the Union of India come with the instructions.
Well,
Your Lordship, at this
well, let's
stage, at this stage, Your Lordship.
Well, if I may only respectfully submit what had fallen for my lords, Article 350B, Millets, does not make a requirement for acceptance.
Yes.
It is only for the purposes of discussion before the Parliament, Millets. That's in sharp contradiction to, Millets, if any report is to be then, Millets, enacted as a law, then it would be different. Then the expression approval of the, Millets, both the houses would then come in. 350 Millets B ends with the presidential cause such report to be laid before each House of Parliament and sent to the governments of the states concerned. So he's sending it to Parliament and the states concerned, Millets.
Lordship, for a moment, if we pause.
It does not say, Millets, that it has to go before Parliament for
Calling for
approval.
a report from the Union of India that what have you done after sending it to the president? What is the status?
Lordship, absolutely. Lordship, the literal language of this 350B says to be laid before each House of Parliament and sent. The President shall cause of such reports to be laid before each House of Parliament and sent to government. Lordship, literal meaning of this would be once the report is placed before House of Parliament, it is the President who is going to send the report to the states. Now, we don't have...
Well, it's the state can then come up with instructions, well, it's whether they have received any report from the office of His Excellency the President of India.
So, the 52nd report, Your Lordship, formally and officially will have to be sent by the President to the state. Not for a moment, I am saying, Lordship, we are not considering the merit of the report on page 145. But this has to be addressed. And Your Lordship will kindly see the second argument forward, Your Lordship, was on the Assam linguistic minority, Your Lordship. Lordship, will just take Your Lordship to page 22.
No, I have said that Assam has brought in an enactment.
Assam, Lordship, page 22, Your Lordship, para 29. For a moment, Your Lordship.
Page 22.
Page 22 of the PIL, para 29.
Okay.
Lordship, this entire exercise in page 29 is the date is very important, Lordship, 3/8/1996. So it is prior, it is not, the Assam has not complied with the 52nd report, Your Lordship. It is prior to the report.
No, Assam had
So
already...
it may have an independent cause of action.
Assam already had the board functioning, Millets. That's why the information was available. In Meghalaya, the board is not functioning, therefore the data was not available before the commissioner.
So, Your Lordship, there are two causes of action. One is whether compliance of 52nd report, which my learned friend has relied on page 145, is an independent cause of action. And then, so far Assam, Tripura and Jammu and Kashmir are concerned, Your Lordship, there are 1996 and all, it has gone prior. That's an independent cause of action, whether, and then we'll have to justify, Your Lordship, the petition justify under which law a board can be constituted.
All right.
So at this stage, Your Lordship, if Union of India is heard only on the issue, limited issue, then maybe we can proceed further.
Please take note. The petitioner is a registered association of individuals. But is registered under the
Societies Registration Act. Millets.
Then you better write a registered society. Of individuals comprising the linguistic minority of this state. The members of this society profess to be interested in the development and welfare of persons of this community. and seek reliefs in that direction. Mr. Paul Lored, senior advocate appearing for the petitioner, submits that all the respondents been served. However, only respondent numbers 1 to 5, represented by the additional Advocate General Mr. Khan, are represented in court. Let a fresh notice be issued by the advocate on record for the petitioner on the respondent numbers 6 and 7, and a supplementary affidavit of service be filed in this court. As long ago as on 1st November 1956, Article 350 capital B was inserted in the Constitution of India. It is in the following terms set out: 350B, page 158. Further to this provision, the Government of India appointed a commissioner for linguistic minorities under the Ministry of Minority Affairs. In his communication dated 29th March 2016, the Commissioner remarked as follows with regard to the state of Meghalaya. Bracket C, pages 145 and 146 of the stay petition. Mr. Depp. You will be able to take out this box. In this report, a table was made specifying the languages spoken in this state, comma, but there is a table. Read out, read out. The number of speakers for each language. And the percentage of the population speaking it. Percentage is given perhaps. A. Benefit of linguistic minorities where their speakers constitute 15% or more of the district. If it is 15% in the district, it should be 15 for everybody.
My lords.
Among the recommendations made by the Commissioner were that the state government should recognize minorities, provide grant in aid to their educational institutions after recognizing them, apprise the community members of their right to obtain education, provide for posts of teachers to teach the language, special to the minority community, they must ensure a record is to be maintained of all language posts. A record should be maintained of language posts as far as practicable. The state government the government of Meghalaya was directed to take note of the suggestions in the report and take action accordingly. As pointed out by learned additional Advocate General, yeah, what have I said? No, that's all. Now what have I said? What? Yes. Then, Learned Advocate General? And Dr. Dr. Mozita. You read Dr. Khan appearing for the respondent numbers 1 to 5 pointed out Article 350B and submitted that the report under this article the special officer cannot claim to be the absolute authority. After scrutinizing the file himself, the special officer has a duty to route it to the President of India. For his final approval. Thereafter, the President shall cause the file to be placed before the Houses of Parliament. He submits that this policy decision DW of 2016. Full stop. It is not known whether it has been laid before the Houses of Parliament or any action taken in terms of the notification. Mr. Paul Lodet, Senior Advocate for the petitioner, submits that the Meghalaya government should immediately constitute a board for linguistic welfare in terms of the said report stroke recommendation of the Commissioner dated 29th March 2016. Paragraph, we have to move step by step in the matter. First step, at the moment, we direct the Union of India Learned Counsel for the Union of India to take suitable instructions in the matter and report to this court before the returnable date. Learned Additional Advocate General for the state, Mr. Khan, may also take similar instructions. List this public interest litigation on July.
10th of July.
Take instructions.
Get my pockets.
Please notice them. Union of India, give them a notice.
We'll cause fresh notice again, Mills.
Number 2 to 8.
Well, it's these batch. Well, it's these batch of appeals from item number 2 to 8.
Yes.
Some development is that we had filed a review before the learned single judge Mellods against the order impugned. That review Mellods is again listed today. I was praying Mellods, if these appeals are taken up after 10 days or so, Mellods, that would enable us to Mellods bring on record what happens in the review. I'm not pressing these appeals
After appeal file review was
Mellods, they were done simultaneously, Mellods, because there was a batch of matters that were filed.
because after appeal review is barred.
After
appeal.
appeal review has been filed, my lord.
No, it's prior, Mellods. Pioneer Carbide, who is the original
Date of
review
filing
petitioner
is-
before, Pioneer Carbide is prior to filing the appeals. It's prior to filing the appeals, Mellods.
So when should we keep it?
After 10 days, Mellods, if it is.
Because both petitions, review and appeal, both are not maintainable at the same time.
At the same
my lord.
time, Mellods, we can't do
You-
that. I'll have to
because
withdraw
therefore
any
he
one
has
of them. I'll have to
And
withdraw.
in review, what has been said that the order of the learned single judge has attained finality, and only on certain point clarification is being sought, my lord, in review.
1 to 8.
1 to 8, Mellods. 2 to 8. Item number 2 to 8.
2 to 8.
List these appeals on 10 July
10th of July, Mellods.
to enable learned counsel to apprise this court of the status of the review application.
Well, I'll leave that.
Number 9.
Well, there is an application seeking condemnation of delay millets in.
This is also review.
My lords, this is a review against a judgment passed by the then Honorable Guwahati High Court, Shillong Bench. Well, as the delay is substantial, we have a delay of 8,315 days, out of which a certain period would. What's that? A substantial period was, my lords, spent in pursuing a remedy that was not available under law. In essence, my lords, the delay is 194 days, but I have to come, my lords, from the date on which the original judgment was
You'll
passed.
be taking recourse to section 14 of
My
the
lords.
Limitation Act.
My lords.
In this matter, my lord, I am for the official respondent 1, 2, and 3, my lord.
Yes.
4 and 5 are the private parties, my lord. Notice has to go, my lord.
Mr. Paul, 4 and 5 have been served.
No, my lords. Notice would have to be issued.
They are affected by the order.
They are affected, my lords. My lord's direct notice, my lords, we'll take steps.
All right. List this application on 10 July. Your respondent numbers?
1, 2, and 3, my lord.
Okay. Respondent numbers 1, 2, and 3 are represented by counsel. Let a fresh service be effected. You've already served.
No, my lords, we'll have to,
Already.
we'll have to take
Let
steps.
service be effected upon the respondent number 4 and an affidavit of service be filed before the returnable date.
Highly pledged.
Number 10.
Yes.
May I please, your lordships, as there is a controversy regarding that my statement, they are in this that they are arguing that I have participated in the case, and whereas I have not participated, I have no idea regarding that. In that circumstances, my lord, I am realizing that case record may be called, my lord, so matter will be clear. That record will speak the truth, my lord.
What is this matter about?
Regarding this dispute of the Gambura, my lord.
Huh?
Gambura, village headman.
Bifurcation.
Yes, my lord. If case record will come, so record will speak, my lord, according to that.
Will speak what?
No, regarding that, I am telling, we have argued that they have not given us any opportunity of being heard. They have not served any
Suppose
notice.
this Shillong district is decided to be divided into 2 districts.
Yes, my lord.
Shillong 1 and Shillong 2. The citizens will be heard.
No, that is.
Or is it an administrative decision?
That is a plain belt is in the Garu Hills.
You show us the rules,
Yes.
notifications, etc. by which authority creates a Gambura, which authority demarcates it, which authority bifurcates it, and which authority has the power to extinguish a village altogether.
Here, my lord. That is the executive instruction.
You have showed, but that relates to the headman, not to the village.
Yes, my lord. That is the Gamburas, but there is no such rule in respect of bifurcation, my lord. In that case, the Guwahati High Court had decided that the criteria and the fact of the case must be taken into consideration. For bifurcation of this matter, my lord, the district council authority, frame some criteria or the notification or any other thing, my lord. As the Gambura are protected under Article 311, the wording they are putting bifurcation, it is directly they have removed me from one part of the village as a Gambura, my lord. So 311 is attracted, they must give me a notice, they must give me a reasonable opportunity being heard. That is one thing, my lord. Another thing is that, my lord, this impugned order has been passed during the MP election, my lord, from 20 March to say 4 June. In the middle, during the election code of conduct, they cannot pass any order, my lord. Whereas they have passed it.
If I can just inject,
let
my
me
lord,
finish.
my learned senior is going beyond the pleading, my lord.
It is there, my lord.
Where is the pleading, my lord, that it was passed during the time of MP election? Which paragraph of the writ petition he has pleaded, my lord?
I am coming to that. You will get enough time, my lord. And moreover, they have passed an illegal order. There's supposed to be the inquiry on
Yes.
inquiry on Alice inquiry they have made in page number 85, 86, my lord. 85 is in the Garo and the translate copy is the 86, my lord, of the inquiry report, this Alice inquiry. Shall I read out, my lord? The Revenue Officer, Garhwil Autonomous District Council, Tura, dated Tura, the 16 November 2023, inquiry report in writing. With due respect and by abiding the office order such and such, dated 7/11/2023, had done the spot inquiry, my lord. At the time of inquiry, many people has created a chaotic drama and argument, but we resolved the situation, started the inquiry. The supporter of Borshi Banda, Gambura, has run away. So therefore we could not take the statement of President Gambura, but we could see that most of the people did not like Abdul Munnab because at the time of need, he always shows the attitude. It is true that the people of Borshi Banda has run away. Therefore, we had asked the people of Goladigli Part 2 that they want to stay under the Borshi Banda Gambura or not. We had even asked whether they need a new Gambura or not. In reply to the question, they replied that they need a Gambura for Goladigli Part 2. So therefore, sir, we are requesting you to divide or to do partition or segregation the said area of Goladigli Part 2. In this respect, my lord, if any inquiry will be held, the district council authority must inform the villagers, and I am being the present Gambura, they must inform me more. But they have not served any notice to the villagers, even to me, whether that inquiry was held or not, my lord. because generally any post is vacant for Gambura or village headman, then district council authority has served a notice to the villagers. 4 or 5 people, maybe sometimes 6 people are applied for the headman.
Where is that in the rule?
No, that is generally they are doing, my lord. Then in the community.
Yes,
My lord. After that, my lord, that another illegal order in page number 89, my lord. Shall I read out, my lord? Case record put up today. The case has come to this authority as one Sri Mohibul Sheikh has filed an application for the appointment of Gambura headman of the village Goladuli Part 2 by bifurcating from the present Borshibanda village, my lord. But here is, they have not given any case number, my lord. The petitioner is the candidate to appoint the post of appointment of Gambura of Goladigli village bifurcating present Gambura of Borshibanda village. The petitioner stated that Goladigli Part 2 is one of the biggest and having huge number of population, which is administered by Borshibanda Gambura, and as such it is very difficult to manage the day-to-day affairs of the village, and also the people of Goladil Part 2 facing serious difficulty and hardship to obtain any certificate or verification from the present Gambura of Borshibanda village, my lord. If it is so, they must complain to the district council. They must issue me the show cause notice, but no such notice was served upon me. Next para, my lord. Therefore, the petitioner prayed that in the interest of the people of Goladigli Part 2, the new Gambura may be created from the village of Borshibanda and appoint a new Gambura bifurcating the village Borshibanda, which will consist of 4 more villages, which are Baliadoba, Bindawari, Shahadoba, and Nodapoti. Last, my lord, the opposite party, Sri Abdul Munnaf, has also filed a written statement objecting the creation of new Gambura area, Goladigli Part 2, by bifurcating the present Gambura of Borshibanda. He stated that the Borshibanda village is not a revenue village, so it is impossible to bifurcate the Gambura-ship of the 2 villages, namely Borshibanda and Goladigli Part 2. He also claimed that the authority has appointed another Gambura of Bolarvita, Borshibanda and Goladigli Part 2 by the name Sayat Hossain, this and that, which he claimed both of them are friend looking and solving all the problem collectively for the above 3 villages, my lord. In this respect, I would like to say that I have not submitted any written statement, my lord. I have submitted an representation when I come to know that they are going to bifurcate it. That one I will come, my lord. In view of the above submissions so made by the parties, and in the interest of the people of Borshibanda Part 2, etc., this authority find it fit and proper to create a new Gambura of village Goladigli Part 2 by bifurcating these villages from Borshibanda Gambura area and appoint a new Gambura. Mohibul.
Any other point?
Yes, my lord.
Any other point?
Yes, my lord.
What?
What is this? No.
Yes.
Point means I am coming to that, my lord. Then they have passed this impugned order of bifurcation.
Bifurcation, readjustment, addition, we have understood.
Yes, my lord. They have passed this bifurcation order after that, my lord. Where is this bifurcation order? page 52, my lord. April 2024. It is for general information or concern that the Executive Committee of Garhwal District Council Tura is pleased to create a Gambura area of Goladegli Part 2 village by bifurcating from Borshimanda Gambura area in the interest of general public, my lord. Here, my lord, then they have appointed the private respondent, which has been already discarded by the order of 20 May 2025, my lord. So we are not agreed for that order, my lord. That is 15 May 2024.
All right.
2 points, my lord, that my learned senior has raised. One is the bifurcation. If bifurcation I need to answer, my lord, is this, my lord, is a policy-making decision of the government, my lord. That cannot be challenged under Article 226, my lord. And how is aggrieved, my lord? He has still remained a Gowra of a particular village, my lord. I will rely on the judgment of Narmada Bachao Andolan, my lord, which is specifically, it says, my lord, in paragraph 233, 234 and 235, my lord, that policy-making decision cannot be challenged, my lord, under Article 226, my lord. Now, my lord, whether he was heard or not, and whether he was aware of this, all this proceeding, my lord, he himself, he has stated in page 36, if my lord may kindly come to page 36, my lord.
Are there any administrative rules for creation?
No, my lord, it is merely a decision by the executive committee, my lord. When there is a complaint or there is an application filed by the villagers, my lord, and there were certain serious allegations against of him, my lord. That is why, my lord, the village was divided. And if in case, my lord, his appointment was terminated, my lord, definitely a show cause notice would have been issued to him, my lord. My lord, may kindly see page 37. His claim is this, my lord, he was unaware of this bifurcation, my lord, where he has stated, my lord, in para 5 of page 37, my lord, that when the villagers came to know from the reliable sources that the few vested interest person lodged false complaint against the petitioner, submit a representation to the secretary. That means he was very much aware, my lord. It is his statement in the writ proceeding, my lord. Now, my lord, page 38 again, my lord. If my lord may kindly see the page 38, my lord. Line number 5, my lord. It is further stated that when the petitioner came to know from reliable sources that few interested person demand unjustified bifurcation of the Gowra from so and so village, submitted representative secretary to the Garhwal Autonomous District Council, wherein the petitioner state in his representation that without obtaining objection from the two village Gowra, the petitioner and Gowra of so and so bifurcation cannot be done, my lord. Under which rule, my lord, he is claiming that, my lord, NOC is required from him? There is no such rule which prescribe that an NOC has to be taken from the sitting Gowra, my lord. Moreover, my lord, may kindly see para 6 also, my lord, in page 39.
Was anybody heard before taking the decision?
With the villagers, there was a meeting, my lord, and my lord, may kindly see the inquiry report. That is on page 86, my lord. Para 2, my lord, that is letter dated 16 November 2023. Second para, at the time of the inquiry, many people has created acquires drama and arguments, but we resolved
Page
86, my lord.
Yes.
Now, para 2, my lord. At the time of the inquiry, many people has created aquatic drama and arguments, but we resolve the situation and start the inquiry. The supporters of Barsevan the Gowra has run away, so therefore we could not take the statement of the present Gowra. That means who, my lord? It is the petitioner, my lord, the appellant. But we could see that most of the people do not like Abdul Manav, the petitioner, the appellant, my lord, because at the time of need, he always show the attitude. It is true that the people of Borsebanda has run away. Therefore, we have asked the people of Goladigri Part 2 that they gonna stay under the Borsebanda Gowda or not. we have even asked whether they need a new governor or not. In reply to the question, they replied that they need a new governor for the Golabanda Part 2. So therefore, we are requesting you to divide or to do the partition the said area of so-and-so village, my lord. Now, it is very clear from the report, my lord, that the public was heard. And if public was not heard, my lord, this is not a PIL that the my learned friend can argue for the public here, my lord. How is aggrieved? Under what provision of law he was not heard?
Was they heard or not?
They was heard, my
Not
lord.
if they heard, if they were not heard also.
They was heard. The villagers was heard, my lord.
Page.
Page 86, my lord. Para 2.
In that case, my lord, they cannot show any notice they have served upon the villagers and to me, my lord. They cannot show. How they can say that public are coming? They are manipulating and making themselves. They cannot show any notice, my lord. Serve upon the villagers and me, my lord.
You file your notes. You
No,
file your
I
notes.
will file my notes.
When was this bifurcation done?
Bifurcation was done, my lord, by the order dated
24. Yes, number 52, no? 52, my lord.
Hearing concluded, CAB usual.
24 April 2004.
Written notes before assistant, before master. By 8 July.
My lord.
Number 11.
May it please your lordships. Lordship, first of all, I would like to beg an apology, Lordship. Time and again, I have been seeking accommodation in this matter, Lordship. Lordship, in this matter, Lordship, I've been informed and instructed, Your Lordship, that the appellant chair, Your Lordship, has approached few senior counsel, Your Lordship, in order to lead this matter, Lordship. But no positive response has come up from them, Your Lordship. Therefore, Lordship, I humbly pray for Lordship, kindly grant me a 2 weeks' time, Your Lordship. As we are in the process of getting an NOC from the other previous counsel as well. Your
Yes,
Lordship.
Mr. Advocate General. Very nice to see you back.
My lord, I can't say because
All right, by. When did you return? Yesterday?
yesterday.
Lordship, if I may pray, Lordship, after 14th of July, Lordship.
After 2 weeks.
After 2 weeks, Lordship. After 4th.
Have you overcome the jet lag?
You know, I'm overcoming.
After 2 weeks.
After two weeks, and that to Your Lordship, if I may pray, Lordship, after 14th, Your Lordship, any date, Your Lordship.
All right, by consent of learned counsel for the parties. The appeal and application are adjourned till July 21st.
Grateful me.
Much obliged, Lordship.